Good morning, everyone. As we come from the Parliament in the public session of the Joint Select Committee established to look and consider the Anti-Terrorism Amendment Bill 2018. I am Faris Al-Rawi, the chairman of this committee, and we are here today with members of the committee, some of whom are between another meeting and this meeting, and you will see joining us shortly, and others who will arrive due to other commitments which are ongoing and which will soon facilitate their attendance. I'm told that I must conduct the usual reminders that we are broadcasting on the internet. We have the ParlView channel, we are on Twitter feed, we are on Facebook, we are on the Parliament radio frequency, and therefore there are multiple media platforms available to the members of the listening public to have a look at the proceedings of this committee. We have received this morning submissions which have been considered by the committee, and we have received submissions some time ago. Importantly, we've had a submission from the Financial Intelligence Unit under cover of its letter dated March 5th, 2018. I'd like to welcome the FIU and its team to this committee and to welcome the assistance which they will provide in clarifying positions that they may wish to traverse. I'd first ask the members of the committee to introduce themselves and then invite the members of the FIU team to introduce themselves, and then we can kick off from that stage forward. Senator Creese, may I ask you to start? Sorry, would you use? Thank you.
Stephen Creese, Independent Senator and Member.
Good morning, Saddam Hussein, Member.
Morning, Faris Al-Rawi, Chairman.
Good morning, Well, thank you.
And that was Mr. Fitzgerald Hines, Member. Ms. Francois, would you introduce your team for the FIU?
Good morning, Mr. Chairman. I'm Susan Francois, Director of the FIU. And with me are, and allow each of the members of staff to introduce themselves.
Good morning, Chair. My name is Nigel Studdard. I'm the Deputy Director of the FIU.
Good morning, Chair. I am Mary Campbell. I'm the Director of Analysis, FIU.
Good morning, Chair. I am Chislon Dubar, Senior Analyst with the FIU.
Welcome, members of the FIU, and for members of the listening public. This is the Financial Intelligence Unit of Trinidad and Tobago, which is responsible for the management of terrorist financing issues, suspicious transactions, suspicious activities across the stakeholders which are identified under the Proceeds of Crime Act in the 5th Schedule, all of the listed entities and financial institutions that comprise the purview and supervision of the FIU. Ms. Francois, may we invite you to make your opening statement if you have one, and then we will ask you certain positions on our plate, and perhaps you may have a few issues to return to us.
Thank you, Mr. Chair, and the FIU wishes to express its appreciation for being invited to make this presentation before the Joint Select Committee on the Anti-Terrorism Bill of Trinidad, Amendment Bill 2018. Mr. Chairman, this bill seeks to introduce certain measures to combat terrorism in its various forms. We need to remember that terrorism is a form of violence directed against civilians by non-state actors to achieve an end goal identified under various ideologies. The inspiration for the attacks could be religious, a religious one, political one, or ideological one. And this is a definition which is incorporated in our present Anti-Terrorism Act. Terrorists believe that they have to inflict the maximum civilian casualties, which will then rock our political foundation. They target civilians in their normal environments, malls, churches, streets, concerts, supermarkets, in order to carry out their violent attacks and gain media attention. So the intention is to have maximum impact locally and internationally. For the period October 2016 to September 2017, the FIU's analysis revealed 251 persons suspected to be involved in terrorist activities. So it's only if we recognize that we have a problem in Trinidad and Tobago can we then seek solutions. And this bill, this amendment bill before us, seeks to provide certain solutions to the terrorism threat in Trinidad and Tobago.
Ms. Francois, thank you very much. May I ask you, in part of your opening statement, I hope I haven't interrupted it. I understood your intonation to mean that you were at an end.
Yes.
May I ask you, for the benefit of the listening public, as we welcome the members of the media who are covering this session as well, to indicate the FIU's role and function in the realm of financing of terrorism or suspicious activities or terrorism. Some of the recent reported statistics that you have in terms of suspicious actions, suspicious transactions, the quantum, the value. And could I also ask for your indication as an entity that is directly involved in the Financial Action Task Force considerations, recommendations, immediate outcomes, and with the Caribbean Financial Action Task Force, to give the population some degree of insight into what drives the process of this bill, what happens if the considerations are not treated with, and what some of the consequences from a financial or jurisdictional point of view may be.
Thank you, Mr. Chair. Briefly, the FIU has a mandate under the law to receive reports of suspicious activity relating to money laundering, but I will focus on financing of terrorism for this purpose. So reports of suspicious transactions involving financial activity related to terrorism must be reported by financial institutions and certain categories of businesses which have AML CFT obligations. These reports of suspicious activity are sent to the FIU. The FIU conducts analysis of these reports. We seek sources of information from many different places, from government databases, as well from foreign intelligence. We put together all that information and assess it and evaluate it. And if we come to the conclusion that there are reasonable grounds to suspect that a particular kind of activity, in this case terrorism financing activity, is taking place, we must send a report to the Trinidad and Tobago Police, the Commissioner of the Trinidad and Tobago Police Service. So that's a role the FIU plays. We analyze reports of suspicious activities, and if the case warrants it, we send an intelligence report onto the relevant law enforcement agency, the Trinidad and Tobago Police Service, for them to conduct the investigation. We need to be clear that the FIU does not have the mandate to conduct investigations. We analyze and produce intelligence. Intelligence basically is information that has been assessed and it's of value to law enforcement. So we would shift and evaluate the information and only send the good information to them. That is what we think or we suspect is related to financing of terrorism activity. During the previous financial year, that's between October 2016 to September 2017, the FIU received 112 suspicious transaction reports on financing of terrorism. and of course related to terrorism activity. In the previous year, October 2015 to September 2016, we received 69 suspicious transaction reports. And the previous years, it was a bit less. So what we are seeing is that the reporting entities, which are the financial institutions and the listed business categories, are becoming more and more aware of the indicators of terrorism activity. They are becoming more informed, so they are better able to identify when these activities are suspected to be taking place. With respect to the sums of money involved, over the 2-year period I spoke about, which is 2015, October 2015 to September 2016, the amount of money involved in supporting terrorist activities we see to be approximately 13 million TT dollars. It is well known that terrorists do not need a lot of funds to carry out their activities. And we are seeing that evidenced by the kind of terrorist attacks we are seeing now. Mass attacks being carried out using very simple devices, low-cost technology. And I would refer to the unfortunate events which have happened in this year. 3 days ago, Yonge Street, the most popular street in Toronto, a terrorist attack through the use of a panel van. In Russia, earlier this year, we had an attack in a church. In France, earlier this year, in a supermarket, using a knife, using stolen cars. So we are seeing the low-tech type of activity taking place. And if we consider the reports arising out of the 9/11 attack in the USA, approximately $300,000 passed through the terrorist accounts over a period of 2 years. And it is said most of that was used in daily living expenses. So the proportion of that money that actually went to fund the attack was very small. Mr. Chairman, I will now address the CFATF, that's the Caribbean Financial Action Task Force, report on Trinidad and Tobago's implementation of its counter-financing of terrorism regime. The Caribbean Financial Task Force is the regional arm of the Financial Action Task Force, which is based in Paris. The FATF, as I would call the Financial Action Task Force, is responsible for setting global anti-money laundering and financing of terrorism standards, which every country in the world must apply. The CFATF in the region ensures that countries implement the FATF recommendations. And in order to do that, they conduct assessments of countries. Trinidad and Tobago was assessed by the CFATF in January 2015, and the report was subsequently published. In that report, the assessors found that our Anti-Terrorism Act our Anti-Terrorism Act, while it criminalized the terrorism financing offense, still had several deficiencies or omissions which was required by the FATF. One of which was in relation to the implementation of financial sanctions on persons on terrorism, terrorists and persons who would have been convicted of terrorist-related offenses. Targeted financial sanctions are those sanctions which essentially involve the freezing of assets. As well, Trinidad and Tobago has an obligation under the United Nations Charter, Chapter 7, when resolutions, UN resolutions are made under Chapter 7, they are mandatory across the world. So we have an obligation under UN 2178 to implement legislation to prohibit our nationals from leaving this country to carry out terrorist attacks in other countries. As well, the sanction provisions in terms of the penalties were considered to be not proportionate or not sufficiently dissuasive. So we have to, as a country, address the deficiencies. Failing addressing those deficiencies within a particular time frame. We don't have all the time. We need to address the deficiencies as soon as we can, would mean that we face the possibility of being sanctioned, I would put it, by the Financial Action Task Force. And you know their sanction can take many forms. We commonly recognize the term blacklisting, but different forms of sanctioning. If, for example, we get a bad report from FATF, when our financial institutions conduct business outside of Trinidad and Tobago with other financial institutions, those financial institutions may apply certain measures, restrictive measures, may restrict transactions coming to them from Trinidad and Tobago. So we may face certain difficulties in conducting our international transactions. So all of these things I just spoke about are just some of the effects. Now, I am sure, and I'm seeing this bill before me, that with this bill, we would certainly be making a significant effort to address the deficiencies as well as, and I think this is the most important thing, to make our country safer for the citizens of this country. Thank you, Mr. Chairman.
Thank you very much, Ms. Francois. May I just, for the benefit of adding one bit of clarification to what you've said, inquire or ask you to confirm whether the time frame that you're referring to before the difficulties of particular types of sanctions can be applied is the time frame that the CFATF and the FATF have given Trinidad and Tobago in the enhanced follow-up process in the CFATF, which is a 2-year period from its mutual evaluation report, which was in 2016, and also whether it also includes the time frame which the ICRG of FATF, that's the International Cooperation Review Group time frame, has had for us. In other words, can you confirm that the time frame is imminent? In other words, we've got until September of this year to make sure that we have certain of our obligations satisfied as contained in this bill.
Mr. Chairman, you're absolutely right. And I think September 2018 is a good deadline because the FATF meeting would be in October and they usually want the information in before a month or so.
Would it be correct to say that you're also equally concerned that with Parliament having to go on a mandatory recess after the first week of July, that we navigate this process as carefully as we can?
Mr. Chairman, I'm sure that the government is committed to making this country safer for the citizens of this country and will do everything to make sure that this bill gets through within the time it needs.
Including the fact that this requires a 3/5 majority support, which therefore means it's not only the government that participates in this process. Thank you. I take your smile as an acknowledgement of what the risk and time frame looks like. Thank you very much, Ms. Francois. Ms. Francois, your submissions were very useful. submissions, your written submissions contained in your proposals of March 5th, 2018, traversed the definitional section, the observation that there was a need for amendment. Really, it turned out because of the difference in the shifting of the positions between Part 2 and Part 3. We wish to tell you that we, as a committee, have considered all of these submissions, and the vast majority of submissions made by you were certainly very favorably looked upon, without going into what the committee may ultimately decide. But we thank you for assisting us with the observed, I should say, typographical or other omissions that we made, the reference, cross-referencing clarifications that you provided. We also were ably assisted by the designated entity and listed entity considerations in your submission, pointing out to us that a designated entity may be different from a listed entity. Of course, that is quite correct. So we were very much enabled by your assistance. That flowed into your observations for the treatment of listed and designated entities, and then your submission with respect to clause 22 of the bill, which treated with traveling for purposes of committing a terrorist act. You ended with the provision of financial assistance for services or property to commit a terrorist act, and we were also quite ably assisted by that. May I ask if there are any submissions that you wish to amplify here, or is it that you wanted for the record to traverse the headlights, the highlights of these particular submissions?
Mr. Chairman, I wouldn't want to repeat what I have just written, and which is before you. But what I'd like to point out is that in paragraph 1 of my submissions, definition of terrorist act, I referred to clause 5E, which should really be clause 5D.
We noted that.
Oh.
Yes. Our Chief Parliamentary Council team, in looking at the cross-reference particulars, spotted that as well. So thank you.
And Mr. Chairman, if I may, I do have some additional comments I would like to make before this
we welcome them.
Committee. Firstly, I am looking at the provision in the amendment bill relating to taking preparatory steps, including but not limited to acquiring material.
Which particular clause are you referring to? Preparatory steps is caught impliedly and then expressly in the bill.
If you would bear with me, Mr. Chairman, I just need to find the appropriate clause.
While your team is looking for the clause, maybe you want to continue speaking about it?
Yes, Mr. Chairman, it's clause 7.
Mm-hmm.
C.
Yep.
Subsection C.
Got you, on page 7 of the bill.
Mr. Chairman, my view is that this clause is and could be a powerful preventive provision, but in my view, it appears restrictive. It says, taking any preparatory steps, but not limited to acquiring material or participating in the planning of an attack in paragraph A, and paragraph A refers to the terrorist attack.
Mm-hmm.
I do not know why we have to limit it by adding on those examples. I will call them examples: acquiring material or participating in the planning. And in my view, I am concerned whether that could then lend itself to being too restrictive. And I would prefer something along the lines, engaging in any conduct in preparation for the commission of the act referred to in paragraph A.
Thank you.
And then I would like to add as well to that same section that it is irrelevant for the purposes of identifying whether or determining whether the person is engaging in any conduct in preparation for the act, whether the intention and preparations relate to one or more particular act of terrorism or acts of terrorism in particular or acts of terrorism generally. The reason I'm saying that is that if this is a preventive mechanism and preparations are taking place, it may be difficult to identify clearly and with enough certainty the particular attack that is being contemplated.
Are you,
and I would, sorry.
If just to add a little lens to that, so your concern in the limitation is potentially not only the application of the adjustum generis principle, which the words can lend a lens to in that, and the law is for the benefit of the listening public, words of limitation limit the clause and the law to the type of consideration that the words suggest. So that's what it means for the listening public. So it's not only that, but you're also hoping to amplify what would otherwise be caught by the Interpretation Act for the inchoate offenses in a broader sense. In other words, then, you don't want only conspiracy, the other usual players that go along with the Interpretation Act. You want to also capture the singular and the plural and general positions. Yes. Could I ask you, if you're developing that idea, to indicate what form of safeguard or filtration you think would be appropriate? Are you proposing that we limit or specify the mens rea aspect to knowingly and willingly? Are you dealing with a concept of recklessness? What's the balance and proportionality to the clause?
Mr. Chairman, the mens rea would be intention.
Intention.
And I have looked at the UK Terrorism Act 2006, Section 5, and I think if we could take a look at that section, we will understand the extent of the restriction that this proposal that we have here at Clause 7C could lead to. And my preference, therefore, is for something more along the lines with Section 5 of the UK Terrorism Act 2006.
Whilst you're on this point, do you also consider, I should back up, the Trinidad and Tobago Police Service made a recommendation for consideration that we look to capturing homemade devices or regular garden-type materials, fertilizers, nails, etc., things that can be used in a very devastating way, but which are simple in their nature, depending upon how they're comprised. Part of it related to the taking of preparatory steps. They also included a consideration as to possession of certain types of material, how to make a bomb, using garden supplies, for instance. And in dealing with that, they were also tackling this tack-on to Clause 7 of the bill, which deals with our preparatory steps. Just by way of clarification, was that within your contemplation? And is it also meant to be, what level of intentionality from a mens rea perspective did you have in mind there?
Mr. Chairman, I did not address my mind to the kinds of evidence that would be required to prove that someone is engaged in a preparatory act. The recommendation I was making is so that the legislation would not be restrictive and it would allow any form of evidence that could convince the court that these showed that this person was taking certain acts in order to carry out a terrorist attack. And it could include any kind of evidence we well know that the types of goods you spoke about are what are called dual-purpose goods. They can be used for a legitimate purpose as well as a non-legitimate purpose. So that comes down, your question comes down to the kind of evidence that would support this finding, which I had not addressed my mind to.
I propose, insofar as I'm interrupting you on your further submissions on a clause-by-clause position, to open the floor for other members, please, to feel free to jump in and ask questions on the particular points that we're on now.
Thank you very much, Chair. Ms. Francois, I understand the concern you have with the restriction of how the clause is actually worded right now, and that you want to widen it with respect to any conduct. Now, in your opinion, is it that you believe that the clause as currently drafted would not capture preparatory steps such as acquiring money, cash, or any material of a financial nature to fund terrorism?
No, I think we have enough provisions in the law dealing with the financing of terrorism, the provisions of funds. This engaging in any conduct in preparation for giving effect to the commission of a terrorist act, which is what I propose, would include as well collecting money, but it would also include, and this is what I was thinking about, all the different acts that come together to prove preparation. So we are treating with the problem before the actual commission of a terrorist act. This is, as I said before, a powerful provision to prevent a terrorist act before it's has even taken place. And this is where I think we need to go towards prevention. So I think, and my view is, that we need to give law enforcement the tools to prevent rather than strengthening the tools, or as well strengthen the tools to prosecute the commission of the act. And this clause here, I see it as very important in prevention. It would include gathering material to make a bomb. It would include gathering funds. It would include gathering people, coming together, distributing information on how to make a bomb. It would include any kind of act. And again, coming back to the evidence part of it, I mean, it's whether all these things taken together will show that the person was contemplating that, was preparing that. It was not an innocent purpose.
Madam Francois, I am particularly attracted to your thoughts on this matter. And you're saying that the UK Act of 2005, their clause, the provision in their legislation that deals with this matter is a little less restrictive than the draft we have here.
Yes, sir. And,
if I could, for the benefit of the public, sorry to interrupt. So thanks to the very able assistance of my team, they've pulled up the UK Act immediately. So Section 5 of the UK Act reads as follows. It's headed Preparation of Terrorist Acts, subsection 1. A person commits an offense if, with the intention of committing acts of terrorism or assisting another to commit such act, he engages in any conduct in preparation for giving effect to his intention. 2, it is irrelevant for the purposes of 1, whether the intention and preparations relate to one or more particular acts of terrorism, or a particular description or acts of terrorism generally. 3, a person is guilty of an offense under this section. A person found guilty of an offense under this section shall be liable on conviction on indictment to imprisonment for life. So thank you for the reference to it. I'm just reading it out for you, member, in case it affects some of what you're doing by way of clarification.
It certainly does, and I'm even more attracted to the thought now having heard that. Because, for example, the police might be pursuing a particular terrorist plot, and then they find photographs of a church 10 miles away, and then there's evidence that the same guys had been visiting that church over the last couple of weeks, or some design of the church. These things would certainly indicate that they are looking at another event apart from the one that is gaining the attention of the police, and you're saying that too that kind of thing ought to be considered as evidence that they are engaged in that kind of activity and serve to prevent the attack on that other church 10 miles away, or discotheque, or I don't know if they still call it that, but some place where human beings, where people gather to entertain themselves, where the impact of the terrorist act could be so grave. That's what you're saying?
That is it exactly, Mr. Hines, and I should have spoken about the photographs as well, because that's something we have read in cases was actually done, the visiting and the photographing of places.
The reconnaissance, yes.
Yes.
Thank you, Ms. Francois. We welcome Member Ramada, who, for the record, was in court and unable to join us sooner. We're always pleased to have Member Ramada with us. Ms. Francois, I interrupted you. I think we interrupted you quite properly on your first submission, which is a reflection on Clause 7C. We thank you for this specific reference to the UK Section 5 of their 2006 legislation. May I ask you to continue?
Thank you, Mr. Chair. My second submission, Mr. Chair, is, and I know this may be a bit contentious, but I am of the view that we should make it a criminal offense for persons to encourage terrorism, the commission of a terrorist act, whether directly or indirectly, whether by directly or indirectly, inciting or encouraging others to commit acts of terrorism. There is an offense in some jurisdictions called glorification of terror. Persons who praise or celebrate terrorism in such a way that it may encourage others to commit the terrorist act. There would be an intent to incite the commission of a terrorist offense, as well as the risk that the persons that you are speaking to, the risk that those persons, it would fall on fertile ground then. So it's an intention, and you know that it will fall on fertile ground. And what you're doing is glorifying the act, glorifying what has happened, and in such a way as to encourage further acts. And I think I could refer you to an article in the Beak magazine of 2015. And this is in relation to Shane Crawford, who has been designated as a terrorist in Trinidad and Tobago, as well as the United Nations. And in that article, here's an interview, he used words to the effect whereby he was encouraging the commission of terrorist acts in this country. So that is the kind of situation I'm talking about. And I think if we need to deal strongly with terrorism and protect our citizens as much as we can, we need to take strong measures to do that. And again, I come back to what I said in the beginning, that we need to, if we don't recognize the seriousness of the situation, then the solutions that we adopt would not be strong enough.
1 second, Member Hines. Thank you. Could I just ask before Member Hines jumps in, would it be broader than that set out in the new Section 3? We lifted this is in Clause 7 of the bill. So we lifted from the parent law what is defined as terrorism, a terrorist act, and we're putting it into a new Section 3 of the Act. And in it we say, a person who, with intent, etc., does any act which he intends to cause creates the likelihood of causing or is likely to cause human loss, substantial endangerment, creation of risk, prejudice, national security, etc. Do you think that this consideration of a glorification offense falls outside of the breadth of that particular definition?
Yes, I do, Mr. Chairman. This definition deals with what is a terrorist act, which is the planned conduct of violent activity, intimidation, and the purpose. The proposal I am thinking about is related to this terrorist act. So it's an offense, I want to make it an offense, to glorify the commission of this type of act which occurred under Section 3. So this is an ancillary offense, if we want to call it that, something in addition to the terrorist act itself.
And again, the application of the Interpretation Act, you think, doesn't catch that, or you want to, in your recommendation, send an express intention to prohibit this type of glorification. You're saying that Parliament ought to send, by its expression of language in the law, a specific message and condemnation of glorification of these sorts of things, using the example of the Debeek publication. Member Hines?
Thank you very much, Mr. Chairman. Yes, prior to the intervention of the Attorney General, I was about to ask whether you found any provision in the law, in the existing bill, that would that we could have tweaked to address that matter of glorification and such like. So, you consider, Madam Francois, that there is no provision in the current bill that deals adequately with the idea of glorification as you have just described it.
Mr. Hines, I agree with you. I do not see any provision that deals with this. There are provisions like under Section 9, which deals with giving support. But I don't think the glorification or encouraging, inciting fits within, it's more, yeah. Fits within 9. And as well, if we look at Section 14, sorry, I'm looking at the Parent Act.
Oh, you're looking at the Parent Act, which I don't have. Yeah, go ahead, Madam Francois.
We have a section, support, under Section 9, which speaks to support. We also have Section 14, knowingly incites or promotes the commission of a terrorist act, solicits property for the commission of a terrorist act. But I am proposing that we go one step further.
I understand the point that you're making. If we look at the provision in the amendment, the bill that is before us, and we revert to where we revert to Section 3 of the Act, our Clause 7, the amendment at Clause 7, if we look at the issue of causing and intends to cause, creates, and so on, if we ascribe the ordinary meaning to the word cause, and even if we look at it from the civil aspect, the negligence thing, causation is a little more direct. You'll want evidence that shows it really leads to that. It's very direct. But the offense that you are contemplating or the suggestion that you are making, yes, is about something separate. Mr. Chairman, I take the point.
Please, Member Ramadan. Thank you, Member Hines.
Thank you.
Good day, Director. Needless to say, the admiration and respect I have for you continues. The great work that you continue to do. Tell me if I'm wrong, though. The capture you wish to have is really about willful encouragement. You see, when we trespass into the area of glorification, we have issues of definition, and it may impact upon rights of free speech. But I think the real mischief here is about willful encouragement. However you want to clothe it, that is at the essence of what we're dealing with, isn't it? So I'm asking if it is at all possible we could move away from the glorification, the word glorification, to one of willful encouragement, and see if we could produce something that we could actually move forward with.
Yes, Mr. Ramad, I take your point, but I am just wondering, when we try to use different words, sometimes we may weaken the intention. But at least the point I made is that it is more than inciting. It is praising the commission of the act, and that way, I would say.
Properly glorifying.
Glorifying it, so that susceptible persons would think.
So it's pseudo seditious
it has
positions.
elements, yes.
Understood. Are you aware of any form of precedent that may exist in other jurisdictions? And we certainly will undertake to look at it and to pull precedents, but is there anything in your research that you've come across?
I wouldn't say definitely at this point in time. I can give you references, but I have conducted some research and have come across the argument, which I could find and then send across to your office, AG.
Thank you very much, Ms. Francois. Members, may we ask Ms. Francois to continue, because we're getting some very interesting submissions by way of further submissions, Ms. Francois. So that's point 2. Let's press on. Member
Mr.
Hines.
Chairman, based on my deep consideration of the point made by Madam Francois, you can imagine a mob in the south of the island using the television and shouting, they should burn it down, mash it up, bomb the place, about something that happening or some problem in the west of Trinidad, or after the event, celebrating that, far removed from the west of Trinidad, but in the south, that sort of promotion and glorification to encourage that behavior before or to encourage future acts of terrorism. And yes, I can see some serious validity to that, because it will be an inducement.
I'd just like to say that, sitting with the veil of ignorance as a legislator, that the current law does have a certain avenue for approach within the new Section 3. Secondly, there is the aid for the Interpretation Act to apply. Thirdly, the dynamics of Trinidad and Tobago's peculiar form of humor and public commentary sometimes could lend one to the need for a very careful approach to this issue. So we're very intrigued by the submission, but the committee will no doubt be cautious as to the nature of our society and in particular the management of our mouths as a nation, because Trinidadians are wont at times to say sometimes the most unacceptable things, which is sometimes intended to mean we are Trini. So there's a careful balance in this approach.
Thank you, Gee, I'm very, very glad you say that, because we have a situation, we have the experience of a situation where a brother by the name, I think his name was Abdul Karim, my good friend, I had known him for years. He was one of those who was charged along with a Guyanese national for attempting to disrupt some energy, some gas line to some airport in New York. And he is either still in custody or, yes, I think he's still in custody.
He died.
He died, yes.
He died. He was,
yes.
His defense included that he was being Trini. However, in the United States of America, the FBI took it as very serious, and we in Trinidad also took it as serious, because that was the first listing that I, as Attorney General, did in Trinidad and Tobago in 2016, in 2015, in November of 2015.
And from the facts that I had gleaned to support your point, Attorney General, and in furtherance of the idea here, the facts that I had gleaned from that is that an agent provocateur, in other words, an investigator from the U.S. into these matters, engaged him in conversation in Trinidad. And in typical Trinidadian way, he spoke, according to you. How did you describe it, AG? Trini talk. but we have to be extremely careful. That small Trini talk landed him in serious is a different thing in another jurisdiction and in their law. So I take the point that these are matters to be considered. Thank you. Thank you.
Member Ramadan.
To my friend, in fact, under the Aiders and Abettors Act, it's aiding, abetting, counseling, and procuring. So we could look at that aspect. The counseling, you see, it has to be a bit more direct rather than an open statement. It has to lead to some falling on certain ears that could lead to action. I'm just cautioning a little bit on
Agreed. Ms. Francois, please.
Thank you, Mr. Chair. Mr. Chair, I now come to my third additional submission. Section 23.
Of the Parent Act listing?
Of the Parent Act. Section 23(4) of the Parent Act. Permits, well, the previous section permits an application to the judge for an order for detention. And subsection 4 of Section 23 allows an order to be made for detention of a suspected terrorist for a period not exceeding 48 days in the first instance. 48 hours, sorry. In the first instance, and then could be extended for a further period not exceeding 14 days.
Yeah.
Mr. Chairman, I may be crossing into a different arena here, but if we are looking at preventing terrorist attacks from taking place, it may be, and the reality of the terrorism threat in terms of the kind of mass casualty terrorism that we currently face, which is horrendous, it may mean that law enforcement may have to intervene earlier in an investigation. Example, in preventing an attack. And it may be something such as Mr. Hines spoke about, information just coming to them, and they have to take action immediately. I am proposing that the powers to detain without a charge be more than the 2 days. For the reason, one of the reasons I just gave, because law enforcement may have to intervene earlier in preventing attacks, and they therefore may not have all the information, evidence that they need to take the matter further. As well, in investigations, terrorism and terrorist networks expand, they span through global networks. And inquiries may have to be made in different jurisdictions with different time zones. That may delay law enforcement, again, in getting the information. As well as one would need to establish the identity of the suspects and gather information on their associates. And we do know that sometimes these persons have forged IDs, stolen IDs, no IDs. So for all these reasons, I think we need to give law enforcement more time to allow them to detain persons suspected of conducting terrorist activities for a longer period of time without a charge. And I know this would involve a lot of discussion and arguments and comments. We are thinking about preventing.
On the clarification, the detention aspects that you're proposing without charge, are you suggesting that the 14-day period should be amplified? I.e. not 48, because remember the formula in section 23 is 48 hours, then approach judge, asked for 14 days.
I am saying that the 48 hours should be amplified.
Right.
And therefore, we may need to also amplify the 14 days.
Good. So you're suggesting on both ends of it?
Both ends.
Right. The initial detention prior to charge.
Without charge, yes.
And then
later on, further detention with a court order.
Understood. Understood. Members,
and for the reasons I gave
understood.
Before. And just one more point I'd like to make with respect to the reasons.
Sorry to interrupt you again. Is this amplified by the fact that our bail amendments, which stood as part of the law prior to September 2016, have cascaded back to the 1993 and 2005 positions? In other words, as you recall, we had provisions for denial of bail in certain circumstances, some of which was anti-gang, others involved anti-kidnapping, and also anti-terrorism was added by way of the scheduled offenses. Is it driven by any part of that consideration?
Mr. Chairman, this is a situation before the suspect actually is charged. So there's not a situation for bail as yet. So this allows the police to have the person in detention to allow them to question him, get information, perhaps get the other persons involved in the activity. So therefore, to stop the activity, and in having this person in their custody, of course, allows, it is not public, so it will allow them the freedom to find out who his accomplices are, if there are any, who is assisting, who is providing the resources, who is financing the operation. So it will give the police sufficient time.
Space for investigation and
yes.
certainty, yes. Can you just give me one reflection? Yes, Senator Chief, please.
The anti-gang, we were running with 3 and 14.
Yes.
So why a different number?
This law was prior in time. Again, I take your point, looking at consistency points. But I think that the committee the members understand clearly what you're saying, which is look to see if a judge can be, in the 14-day scenario, invited to consider a larger frame than 14 days, and look to see if the police ought to be facilitated prior to going to the judge in the 48 hours for a improved position. Do you have any idea as to what time frame in the 48-hour change you're looking at?
Mr. Chair, the UK has a provision where 14 days, I believe, is given in the first instance, and thereafter maximum of 28 days. And there are suggestions to extend the period of 28 days for the judge to give an order, not exceeding 28 days, to 90 days. So
you're bringing out big guns.
I am just explaining what is in the UK legislation.
Thank you, Ms. Francois, because I just remind that your perspective is fed by the network in which you operate, which is the Egmont Group. And the Egmont Group is a very large group of FIUs, and that therefore you have the benefit of a lot of international feed-in and consideration apart from your own research. So I just wanted, for the benefit of the public, to remind that your network of operation is a very significant one, and it is a global one. And I thank you for the perspectives. Can I ask members, are there any questions on this particular point? No? Ms. Francois, please.
Mr. Chair, may I now turn to clause 19 of the amendment?
Yeah.
Which introduces a new section 13A. And makes it an offense for a person without lawful excuse to receive instruction or training in certain kinds of activities that we call terrorist activities. And as well, we have this expands the existing Section 13, which already makes it an offense for a person to give training. So now Section 13A is making it an offense for a person to receive training. What I'd like to add in these two scenarios is a person, to make it an offense for a person who attends at a place used for terrorist training, either in Trinidad and Tobago or outside of Trinidad and Tobago. Of course, with the requisite intent, the person knew or reasonably believed that that kind of training was taking place. So it's mere attendance at the training site, either in Trinidad and Tobago or outside of Trinidad and Tobago with the required intention.
Do you want to add to that the similar caveat of the exception for lawful excuse? And let me say why. There may be very real circumstances where somebody may have a good reason for having been there. An undercover agent, a police operative, somebody engaged in intelligence work, human intelligence, etc., or somebody caught at the wrong place and wrong time who simply didn't know. Are you proposing a similar form of exception?
Mr. Chairman, I think that could apply without lawful excuse. Attendance at such a place.
To be clear, the mental intention side of the offense, the mens rea, is knowingly, intentionally, and without lawful excuse.
Yes, Mr. Chairman.
Thank you.
If I may.
Yes, please.
I do not know if we properly capture an informant. You may have a person who may be part of the organization, but feeding, as you say, intelligence back. But that does not, I don't know if our formulation captures that. I don't know. I just ask you to mark.
The submission coming from the TTPS and from senior counsel's advice was that this would capture the informant or the operative as well as the whistleblower. And there was significant concern and reflection from the members of the Muslim community, and the example of the Venezuelan experience came by way of their submissions, that somebody may perceive a particular activity as wrong, a paintball training exercise, attending at a gun range where it's lawful in that country to attend at a gun range, what somebody may allege to be military training and exercise, which was not, because there's a lawful excuse. You're interested in marksmanship, it was permitted, you were invited by someone to that location to do that within lawful authority, etc. So I'm trying to capture the balance between the two. Senator Crease.
Senator Crease.
I was wondering whether, just as how you have a zone,
yes,
whether it could be pre-designated, you know?
I see. Senator Crease is raising the issue, you know, in the new clause 15 that we propose, that we're treating with this concept of a designated zone, and you've addressed part of that in your written submissions. I think Senator Crease's question, if he'd permit me, and please correct me if I'm wrong, is attendance in a declared zone, or is it the broader context of that place which is used for terrorist purposes? I think it's the latter, yes?
Yes, it's the latter.
Okay, thank you. Member Hines?
The where this provision is drafted, 19.2, clause 19.2, the what do you call it? What ball? Paintball? The paintball defense doesn't help, because this says a person who, without lawful excuse, intentionally or knowingly attends training or receives instruction or training from a terrorist group. So it is not so much about the place, it's about the activity and knowing that the intention, and one knows that it's terrorism. I suspect what the proposal is trying to deal with is the young man who knows that a certain place in the forest is being used for training terrorists. He takes two persons who are going for that training to that location and waits until they finish get the training. So he is not going to do the training, but he knows what they are about, and he takes the job with his little PH car to take them to that location and to wait for them when they finish. He has no intention of being a terrorist, but he knows what they're going there for, and he takes the job to carry them.
R.V. Gallagher.
Huh?
R.V. Gallagher.
Yes, yes.
So the IRA construct.
Yes.
The driver to the IRA bombers.
And I have a suspicion that this is what the proposal is intended to capture. It is to deter persons from attending places where there is knowingly some kind of training. Am I correct, Madam Francois?
Mr. Hines, so it's more than just receiving and giving.
Yeah, I'm not going there to receive it, but I'm going there knowing that that activity is being conducted, and I'm going. So in other words, this law, or the law as proposed, is designed to deter me from taking that job. Huh? Aiding and abetting, as it were. Thank you.
Thank you, Member Hines. Ms. Francois, would you press on? How many more submissions do you have, just so I can gauge myself?
Mr. Chairman, you'll be pleased to know this is my last submission.
I'm not so pleased, you know. We're very, very intrigued by the submissions that you're making because of the information pool that it comes from. Please, proceed.
Mr. Chairman, my last comment is in relation to clause 22. 4, which inserts a new section 15C and 15D. And 15C and D are along the same lines. 15C requires a person who wishes to travel to a declared geographical area prior to such travel must give notice to the Commissioner of Police in a form referred to as notice to travel. And 15D is along the same lines in relation to a child. Notice must be given if a child is being taken to such a geographical area. I am concerned about the fact that the section does not state how much time prior to the travel should notice be given. My thinking is that the reason for the notice, apart from the Commissioner of Police having a database with the names of persons who have gone, is to also give him the opportunity to prevent persons from leaving. I may be wrong, but I am thinking this is one of the ways in which we can comply with UN 2178, the prevention of travel, excuse me, by the Commissioner of Police of persons suspected of committing terrorist acts. So I would want to see a time frame within which the person must give notice. And we must therefore amend section 15C and 15D. New section 15C and 15D. As well, Mr. Chairman, after notification to the Commissioner of Police, and I'm looking at 15C, subsection 4, subsection 3, 2 and 3. The notice is given to the Commissioner of Police, and subsection 3 says, upon return, if notice was not given, he has to provide the Commissioner of Police with reasons. But nowhere here in any of these sections is there a provision for the Commissioner of Police or other authority to refuse permission to leave. So far, 2 comments. We need to have a time stipulation by which a person must give notice to the Commissioner of Police. Secondly, we need to provide for a refusal by the Commissioner of Police. And I am thinking as well, with respect to 15D, wishing to take a child to a particular geographical zone, and the only requirement is to give notice to the Commissioner of Police. But why is it we are not going further to protect the children in the sense of making it a little more difficult for the person, such as obtaining perhaps the consent of the other parent, obtaining perhaps the consent of the court, obtaining perhaps the consent of the Commissioner of Police to taking this child out. So, with respect to an adult, what I am proposing is that if the adult under Section 15C wishes to travel to a declared geographical area, he gives notice within a particular time, providing the reasons, etc. If he wants to take a child with him out of the country, he has to obtain further consents apart from giving the notice to the Commissioner of Police. So I want to see an additional protection for the child being taken to this declared geographical area.
Thank you, Ms. Francois. If I could perhaps assist with the formula which the drafter of the laws had in mind, which is the Office of the Attorney General. Because the declared geographical zone is something which is very fluid, because it could happen at a moment's notice, because it involves our citizens being all over the earth at any one point in time for different purposes, it was very hard to prescribe a time frame, because a declared geographical zone may happen. Somebody may be in Israel, they may be passing through Syria and not know that it has been declared as a geographical zone, and therefore putting a time frame prior for somebody who just didn't know, even though we have the caveat for lawful excuse, became very difficult. Secondly, we intended that we provide for the alternatives: prior, during, after. Thirdly, we intended that the law really catch the circumstantial evidence side. Did you go there? Why were you there? Compel a reason to give you that information, because otherwise the presumption kicks in. And we did that knowing that we would have the interoperability of the police mechanism called Interpol going to work. Interpol blue notices, Interpol red notices, to allow for the tracking of that information. But we also did this because a number of our citizens who find themselves in the Middle East, if we use that as an example, an area that many people have thought is an area of focus. I'll declare my interest. I'm half Iraqi, I'm half Trinidadian. I have reason to be there, for example, just as a human being giving this interest. I have family members there. There's certain parts of Iraq which are under potential of being a declared zone. You could look at Mosul, or you could look at Kirkuk, or you could look at certain areas in Baghdad. But what we wanted to do was to provide a balance for people who find themselves on lists, who find themselves subjected to other countries telling them, look, you are somebody that we have an interest in, and you're potentially a terrorist. It allows the government of Trinidad and Tobago to say, hold on, we know this person gave us notice, they traveled for Hajj or Umrah, they were passing through, or let's use my own example, they went to visit their grandmother or relative, there was a family incident, you had to be there. So it was to provide for the first time the opportunity for Trinidad and Tobago persons who were innocent, but who were mischaracterized or mislabeled, to have their government say to another government, we know this person is on the wrong list for the wrong reasons, and here is the evidence which we will share with you, either by way of Interpol or by way of MLAT, mutual legal assistance under the central authority provisions. So the from the drafting team, even though that's without prejudice to the Joint Select Committee's work, was to try and achieve this balance in this fluid zone. I should ask you to note that your recommendation for the prescription of a time frame is coincidentally met by submissions from the TTPS to the same effect. And both of those submissions are in square contradiction by some other members who say, get rid of the clause entirely. So it's a rather contentious position, which I think is better understood now by those who objected to it, because many people had missed the fact that we were providing an avenue for exculpation in wrong circumstances for the first time. So just giving you a bit of an insight, that's just from one member of the committee. That's the drafting end of the committee, the government side. May I ask members of the committee who wish to make any other interventions to do so now? Senator Creese?
Yeah, I'm thinking about the Nigerian situation where those 30 girls were abducted.
Boko Haram.
Right. Did the Nigerian government, any government in the surrounding areas, declare a zone there?
So this law, in terms of where we got a precedent for it from, comes out of Australia. And the Australian model is using this declared zones. The declared zones phenomenon is intended to capture the largest issue out in the population right now. That's the global population, which is the concept of the foreign terrorist fighter. The information globally is that Al-Qaeda, ISIS, etc. are crumbling. But the phenomenon is that retreating armies commit the worst atrocities. And we're now seeing the phenomenon of foreign terrorist fighters, ideologists in foreign countries using panel vans, knife attacks, other forms of positions to commit acts of terror in foreign territories. Australia was the leader in the pack in terms of how the treatment of foreign terrorist fighters were managed. But I want to remind that the United Kingdom and the United States and other jurisdictions have very, very, very radically advanced measures to treat with terrorists and FTFs. They have specialist courts. They have limited evidence. In other words, then they may not give the full amount of disclosure that we do in our courts. They have rights against self-incrimination, which are put aside completely. Your right to remain silent is not a right to remain silent in the United Kingdom, in the United States, in the manner in which they say, if you wait until the trial to give your excuse and you had 11 opportunities before and you stayed quiet, they draw an adverse inference from an evidential point of view. So we're trying to treat with this phenomenon of foreign terrorist fighter, and the key information that was missing to connecting the puzzle was where did you travel and why and for what purpose. And putting an obligation for the first time to say why had two benefits. One, it could connect those who were genuinely guilty into the equation, or it could exculpate people who were entirely innocent and who were the victims of discrimination or profiling. And that provided the balance for the two. I hope I've lent some assistance to that.
What I was concerned about is what triggers the declaration of the zone, because I was wondering whether...
So the government of the Republic of Trinidad and Tobago, under the Ministry of National Security, it is the Minister of National Security in Trinidad and Tobago who declares what a zone is or is not. And that may be met with international objection. For instance, it would be open to... Let's suppose somebody in Australia said Port of Spain is a declared zone because there was an attack. We would have the international perspective and the Committee of Nations to talk to Australia and say, well, we object to this phenomenon. Let's suppose somebody said, Yonge Street, there was a terror attack, and Canada, the city of Toronto, ought to be a declared zone. There is, of course, the ability to do that, but, of course, the international balance as to how it's managed.
See, why I raise this is because somewhere at the back of my mind, I'm thinking nobody declared any part of Nigeria to be such a zone. And I think all of us here would agree.
Well, not yet, but Boko Haram is listed as a terrorist entity, for instance,
right, so
by the United Nations.
They're listed. We all know that they abducted 30 persons.
Yeah.
No zone.
It's now an evolving phenomenon. This foreign terrorist fighter phenomenon and how you treat with it is at the cutting edge of where the anti-terrorism law is. Please, Senator Hussain.
Thank you very much, Chair. Ms. Francois, earlier on you indicated that there are about 251 suspected terrorist activities, financing of terrorist activities, sorry. Am I correct? I think you said
251 persons suspected of...
Persons.
Persons.
Okay.
Suspected of conducting terrorist activities.
Oh, terrorist.
But all the
do you have any
together.
figures regarding specifically financing of terrorist activities?
I do have some statistics with respect to suspicious transaction reports received by the FIU in relation to financing of terrorism.
Ms. Francois, forgive me for interrupting, but in your reply, and because this goes global, permit me to ask you to clarify the following in your response. The FIU receives suspicious activity reports, suspicious transaction reports from financial institutions and from listed entities. The listed entities are the individuals and entities listed in Part 5 of the Proceeds of Crime Act. They include attorneys at law, pawnbrokers, real estate agents, accountants, etc. So they're financial institutions and listed entities. The FIU, when it receives these SARs and STRs, lists them and then investigates where money may or may not have gone to. If money goes, for instance, to an entity which Canada has listed as a potential entity linked to terrorism, then a flag goes up. However, I want to be cautious, and I want Ms. Francois to correct me if I'm wrong. It may very well be that the United Kingdom has an exactly opposite point of view. So, in the Zakat formula and in the example where you give international humanitarian assistance, I can say with certainty, as central authority for Trinidad and Tobago, I have met situations where one country views X entity as potentially associated with terrorist activities, and another country has the exact opposite view. But the FIU has to flag it in any event. Am I correct, Ms. Francois?
We would flag it if it's suspicious.
Right.
Because this is what the law says. We look for suspicion. We do not focus only on the name of someone. And it is true, some countries have their own domestic lists of terrorists which are conducting terrorist activities within the country. I will give you an example. The FARC in Colombia, and then later on they were granted amnesty and immunity, so they were delisted or no longer terrorists. The OFAC, US, has a list as well of their domestic terrorists. We in Trinidad also have our list, the consolidated list of domestic terrorists, persons we have listed, as well as persons listed by the UN. So all of these are lists, terrorist lists, and the reporting entities, the financial institutions who report these transactions to us, these suspicious transactions, have to check lists which are used commonly.
Can you
the
say,
OFAC?
Can you say, sorry to interrupt, can you say in your work with the FIB, the Financial Intelligence end of the TTPS, whether you have actually had a report that of this number, that there have actually been formal investigations to a more limited number? In other words then, does the flagging of 261 mean 261?
Means 251, as I said.
251
persons we suspect. The suspicion would arise from their transactions. The suspicion would arise from their associates. The suspicion would arise as well from what law enforcement would have told us. These are persons of interest.
Do you know if any
analyze their transactions?
Do you know if any charges have been laid or activities from the FIB in terms of their report back to you without disclosing any of the particulars?
I have no information from the FIB on charges under the ATA, Anti-Terrorism Act.
Thank you. Please.
Now, with respect to the
Please, John.
financing, those figures would be, I think I didn't get the figures, but those figures would be both financing within domestic and international, right? It will be a consolidated figure between national and international.
It would be any sums that we observe, whether it's staying in Trinidad and Tobago or going outside of Trinidad and Tobago, that we suspect is related to financing of terrorism activity.
The reason I ask is because as we were on the topic of the listing of geographical areas, I would imagine that the Attorney General will also consider financing from Trinidad and Tobago to foreign states. So I'm just thinking, probably just, I don't know if you would have the statistics here, but where exactly do we see our money going to in terms of foreign jurisdictions, which in terms of where most of our these transactions are taking place?
Suspicious transactions
for
related to financing of terrorism.
Yes.
I was hoping that Mr. Ramada would have tugged Member Hussein's sleeve because of certain runaway provisions that could happen there.
I'm not asking with regards to the specific country, but in terms of the regions. Yeah.
You see, that may give an unfortunate lens. I'll tell you this, the government, for instance, as Attorney General, I have no knowledge whatsoever of what Ms. Francois is saying because I'm not allowed to have that knowledge. It's only the Trinidad and Tobago Police Service, the FIBN, that has that information. There is no executive involvement at all in that, nor can they be. For the record, I welcome Dr. Muninal. We received your apology that you were running late for a conflicting occasion.
The only reason I ask is because of the geographical area in terms of the Attorney General being the person to make the designations of those.
The Attorney General does not. The Minister of National Security designates the area. The Attorney General's function under the law is only to deal with listing of entities or individuals in the court for the court to consider whether that should happen.
And I would imagine that they would use
No, we are not permitted.
Purpose.
The Financial Intelligence Unit Act is specifically constructed to exclude everybody that is politically appointed. It is only the Trinidad and Tobago Police Service that receives the FIU's information, and other FIUs abroad when they engage in reciprocity.
In terms of listing, we don't necessarily use.
We have for listing, we have no information. We are not permitted the information until the TTPS lays a charge, has something which is now publicly available, and then the DPP may or may not disclose information to the court. So for the abundance of caution and for clarity, the Attorney General has no role, no member of the executive has a role, even though the FIU falls as a subset in terms of financing from the Ministry of Finance. The Minister of Finance has no role. The director of the FIU is not somebody who's appointed by executive discretion, nor is the director reported. And there's a security of tenure by way of the Public Service Commission and other facets. So it's well organized as an administrative FIU. Okay? Please, Minister Hines.
Thank you very much. Since I may not have occasion to speak at this forum again, Madam Francois, I must personally express my deep admiration for the international perspective that you brought to these deliberations this morning. It is obvious, it is patent. And it really tells me as a citizen of this country how in some ways, and of course the amendments that we are pushing is to make us, to meet the recommendations of the CFATF and the FATF, and to comply with our international obligations, and that's great. But as a social platform, as a country, I think that we are still very much asleep and not alive to the reality of the things that we are seeing. And I'm very pleased to know and say and express in candor that because, as the AG indicated, your international contact in the Egmont Group and otherwise, and the exposure you are having there, we are great beneficiaries of that international perspective and you helped wake me up this morning. So I just want to say, as a citizen with access to you here, thank you very much for that. Now, I read in another place recently, in terms of your last annual report, because you are obliged under the Act to report annually to the Parliament. So I would have read your last report, which I seem to recall not having a copy in front of me, significant increases. I estimated it to be very significant increases in the numbers of suspicious transactions over the previous period. And then you quoted figures today of 112 and 69 from 2015 to 2016. But my recall was that it was very significant in terms of the sum of money. And when I heard you say 13 million this morning, it didn't match in my recall.
That's for terrorist financing. What you're referring to is the 22.5 billion for the suspicious SARs, STRs. So that was the subset of it.
All right. Okay. So what you revealed was purely about terrorism, which brings, yes.
Yes. Only 13 million in relation to financing of terrorism.
All right. Great. Which brings me to the point I wanted to raise now that I have clarified that. The mandate you have, the act that you have in your functions, it permits you not only to deal with terrorist activity and financing, but generally suspicious transactions. I seem to recall back in the 90s, Mr. Chairman, that it was the United States government who told the Trinidad and Tobago government that their money laundering apparatus, FIU kind of arrangement, is what saw the movement of large sums of money from Trinidad to the United States. It attracted their attention as possibly terrorists. And when they investigated it, they found out that it was not about terrorism, but it was plain old simply shipping out stolen money, corruptly obtained money. And a lot flowed from that and still flows. And in light of the fact that we now clarified, the 13 million has to do with terrorist financing, suspicious transactions, and we spoke about $22 billion other transactions. It is correct for me, based on my reading of the report and the extrapolation from what you said, that there has been in your last report an identifiably significant increase to the sum of 22 billion in the movement of money that caught your attention. And I know, as the AG clarified, you relate to the police. Huh? Yes. Yes. So it is hoped, and this is just my concluding statement, it is genuinely hoped as a citizen of Trinidad and Tobago that we don't only focus on the terrorist business, and that though the 22 billion, that significant increase that you detected last year for the period under review, movement of money that caught your attention, I really do hope that your organization, you and your organization, other persons who are here today, are very seriously, aggressively even, actively involved in communicating those observations to those who you must report them to. But I am not getting a sense, based on my knowledge of the 22 billion, I'm not hearing anything that suggests that it is something is happening around it. I can't say more, so I'll content myself with that. If I might repeat, I'm not hearing, when I read that 22 billion, I'm not hearing any other, I'm not feeling any other activity to tell me as a citizen who read those figures that something is happening around 22 billion that you saw moved.
Mr. Hines, if I may, the 22 billion that we reported came from 877 suspicious transaction reports. And that led to the FIU sending 140 intelligence reports to local law enforcement.
I thank you very much.
And 42 to foreign law enforcement.
I thank you very kindly.
Yeah, we've heard about outflow to finance terrorism out of our shores. Is there any inflow into Trinidad to finance terrorism here?
Sorry, the 13 million I referred to involved the money flow, either into the country or out of the country. Intra-island money flow as well has been observed with respect to suspicion of financing of terrorism.
Yes, please, Dr. Munilal.
Thank you very much, and good morning to all colleagues. Just to follow up on that point, maybe I missed it earlier. You stated earlier that there were 800 and something reports of transactions, suspicious transactions, and that led to 100 and something reference to the law enforcement. 140?
The 877 suspicious transactions reports that we received led to 140 intelligence reports to law enforcement in Trinidad and Tobago, and 42 to law enforcement and FIUs outside of Trinidad and Tobago.
To follow up on the question I think the chairman was on earlier, is there a recording mechanism or some other type of correspondence exchanged that gives your organization any update, as general as it may be, on the status of ongoing investigations or inquiries into those matters, in a general sense, that you know you made 150 intelligence reports, 75 were proven to be without foundation. You understand the point I'm making? What is the feedback mechanism that you can track that these things are going somewhere and something is happening?
We do get feedback in a way from the TTPS in terms of whether charges have been laid. And the feedback on the intelligence reports we would have sent is more in a general way, apart from those persons who have been charged. So when persons have been charged, we are told, yes, charges have been laid. But with respect to the other matters, the investigation is ongoing.
And just to remind the public that of that 22.5 billion, which you observed last year, some 13 odd billion was interrupted by way of reporting from the FIU, so that transactions were stopped as a result of the intelligence feedback and operations of the FIU.
Mr. Chair, may I clarify?
Sure.
The 13 billion in stopped transactions, we need to credit the financial institutions with that, because they were able to identify the transaction as being suspicious and connected to money laundering or financing of terrorism, and they took the decision to stop the transactions. But the requirement under the law is that they must still report it.
Sure. Well, what I'm referring to is the fact that if they had not an obligation to refer to the FIU, if the FIU had not trained, if the FIU had not audited, if the FIU had not received more staff as it did, if the FIU didn't get more computers as it did, if the FIU didn't attend all of the training seminars as it did, they would not have been in a position to cause that result. So I'm giving you the compliment to you, Ms. Francois, for such a huge increase in activity that has been observed in your reports.
Thank you, Mr. Chair, and it comes back to training, it really does.
As it was in 2009. It's very rare we get this joint enterprise, Ms. Francois, so forgive us for taking advantage of it to all celebrate good work. I think that the concern raised by Dr. Munilal was, at least as I understood it, that the population is really anxious to know that whilst the FIU is doing a good job on its end, what happens next? Where is the TTPS's end of it? Dr. Munilal?
Just to follow up, Madam, do we have, if we do, and you can tell us, some sense in a chronology, 2015, 16, 17, whenever the period may be, of convictions arising out of intelligence referrals, intelligence reports, and so on, pursuant to this? Of the reports that you would have, the suspicious transactions that you would have flagged, or intelligence reports that you may have sent, you said the police would inform you as to if charges are laid and so on, but do we have a sense, just to close the book, so to speak, how much convictions you have had in any period pursuant to this?
I can answer that immediately. Disaggregated across money laundering and others, there have been no charges for money laundering that have resulted. They are all at the preliminary inquiry stage. However, there has been measurable success in cash seizures and forfeitures, which is part of it. On the TF side, which is the terrorist financing side, there have not been, to my knowledge, any convictions on that end, which is what drove the move in the law, which we considered recently, to move it from indictable to summary in the amendments to the Proceeds of Crime Act and in the improvements to the FIU Act. So in getting to the efficacy and the measurables, we did some tweaking to the law very recently.
Chair, the thing that I am concerned about, although I know our jurisdiction here has to do with terrorist financing, anti-terrorism, but I can't help wondering that the information which their unit would gather over time stops at the door of the police service. And our financial intelligence system is not fully integrated in the sense that the Inland Revenue Department is not on this loop. And the biggest criminal who had been put away in the States was Al Capone. And he was put away by the Inland Revenue Department, not by the regular police. So I'm wondering, where does that leave us?
If I could join in, Ms. Francois, feel free to correct, join in, add. You're quite correct, Senator Crease. The FIU is limited because it was originally constructed as an administrative FIU. There are different models for financial intelligence units. One of them, very importantly, is a law enforcement type FIU. That is under active consideration, and that, under this government's perspective, will form part of a fillip that we intend to introduce in our civil asset forfeiture regime in who does the prosecution, how is it done, and where does it rely. The FIU and the BIR do have MOUs between each other. Am I correct, Ms. Francois?
Mr. Chairman, that's not accurate.
Okay.
We do not have a sharing agreement with BIR.
Do you provide them with information, however?
We provide them with intelligence reports. We are required to do that under the Act. So once there is a suspicion of a tax offense, we send an intelligence report to the chairman of BIR.
Great. But I understood, sorry, and forgive me for using perhaps the wrong expression. I understood the MOU to mean that you would provide them with information, even though the statute doesn't say that you need to.
Law says we must.
I see. Okay. I hadn't observed that. Thank you for the correction. So it does, but there's no reciprocity, to be clear, right? So the BIR does not.
BIR does not share in return.
Pursuant to Section 4 limitations in that act, right? I'd imagine. So I don't know if Ms. Francois wants to take the next step in terms of confirming her advocacy for a law enforcement type consideration. I would imagine that that's the next step for this country to consider when and how one moves to an improved structure for enforcement, as other countries have done.
Thank you, Mr. Chair. We do know that the FIU was created in 2010 as administrative type unit, which means
was it April 2010? I can't remember exactly when. I saw the drafts coming at 2009.
I think it might be February 2010.
February 2010, sorry. It was POCA that came up in 2009, okay.
Yeah. And as administrative type FIU, which means that we do not have investigative powers. So our mandate is to receive. We operate as a receiving and analytical and intelligence producing type of FIU. As well, we were given the additional mandate to be the regulator for certain types of financial institutions and listed business. That means businesses which fall within the AML-CFT regime. As a supervisor, we have to make sure that these entities perform their AML-CFT legal obligations, and we supervise them, conduct outreach, etc. So we have a twofold function at this point in time. I do know that certain recommendations had been made to consider whether a different type of structure, different type of FIU would better serve the needs of the country. And it may be the time now. We have been an FIU in existence going on 7 years. And we know the work that is required. We know what must be done in order to make a meaningful dent in criminal activity in relation to money laundering and financing of terrorism. So I am not proposing that we change the structure. I am thinking it may be now the time for us to consider whether a different structure might work better and conduct the necessary research and analysis. We may very well come to the conclusion that this is the best FIU for the country, because I do know other countries in the Caribbean which had had the type of investigative type FIU change and created an administrative type FIU recently, as happened with the Turks and Caicos Islands.
Thank you very much. Yes, please, Member Hines.
What might have prompted that? Because one would have thought that the investigative model, that's what it's called, is a lot more potent. What might have motivated a reversion to, or at least a transposition to an administrative model in the example you just gave? Just a curiosity.
I could give one reason. Yes. Because the FIU is getting additional responsibilities. More responsibilities are being imposed upon the FIU, more than was envisaged. The creation of the FIU was an FATF mandate to serve as an information and analytical arm to assist the investigator. And that's what we started as. But then many FIUs got this additional supervisory role. And supervising the entities, listed business financial institutions, require a lot of resources and a lot of time. So to have the additional investigative responsibility meant that certain aspects of that FIU's work was suffering. And they decided, I think that's one of the reasons, to separate the regulatory and intelligence function from the investigative function.
Finally, and for my own part, might I ask, with your leave, Mr. Chairman, you would have, obviously, it is obvious that you would have perused, you would have studied, and you commented very sensibly on the provisions of the entire existing legislation and the amendment bill here today. Given your independence and given the fact that this committee sought your presence here today to be the beneficiary of your views on this bill and its implications for the existing law, do you consider the measures or the measures in front of us useful as director of the FIU for Trinidad and Tobago generally, or do you have any other concerns about it?
The measures introduced by this
bill, which we have asked you to come, do they, quite frankly, some of the measures, and I don't want to buttonhole you, but some of these measures have created a lot of discussion in the national community, concerns and so on. You are here and commented upon the act, commented upon this bill, obviously would have gone into it in great detail as an independent stakeholder in this country. I just sought your your views in the generality upon it.
In relation to this bill addressing certain deficiencies in our present ATA, Anti-Terrorism Act, I think it goes a long way. And as well, I believe the provisions in this bill, of course with my comments, will also go a long way to making this country safer for our citizens. I see within the bill many provisions relating to preventative measures. And with respect to terrorist activity, I do think law enforcement needs to have a strong toolkit when it comes to preventative measures. Of course, and we need to be cognizant of this fact, terrorism mutates. So what is right for today and in the future may need to change later on. We are seeing new forms of terrorist activity, new forms of violent ideology. So amending this now does not mean that we should sit back and be happy for the next 20 or 30 years. The time would come again, I would expect it too, where we will have to amend the law to make it better for our country.
Thank you.
Thank you very much. Ms. Francois, may I adopt and echo on behalf of all of us the complete sentiments expressed by Minister Hines a short while ago for your submissions and for the FIU's hard work in this field. It is very much appreciated by every member of this committee, and we thank you warmly, you and your team, for certainly giving us a very strong perspective on where we need to be and where we are. If there are any other submissions that you wish to make, I mean, we thank you. It was very fulsome, the oral amplification. We took careful notes. But please do feel free, if you wish, to confirm anything by way of a further submission. We have taken careful notes of that which you've provided already, and we add them on to the submissions we received in March as well. May we thank you for your continued effort and for the work which we know you will certainly produce for us again. With that in mind, can we then suspend these particular proceedings? We will go off camera, and we thank the listening public for paying attention this morning. We will return just to wrap up the affairs in camera of the committee's work, and therefore we suspend this meeting.